Lawyers of Reddit, what's your most badass I rest my case moment? Opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, first thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, I'm done with this guy. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep, so I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that rule meant they could do X. I tried, multiple times, to point out rule literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, show me where rule says X. Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, Judge, I have nothing to add. It was pretty fun. Guy in a divorce case transferred money to the Equity Preservation Corporation. I looked at the corporate filing, there were only 2 shareholders. Knowing who they were, I asked on cross-examination. He denied knowing them. I then asked about them by name. He admitted they were his parents. I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "Fuck you, judge lady. You a stupid cunt. Fuck you all for taking my fucking kids, you fucking cunts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. I do mostly solicitor work, so if I'm doing my job right I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions it worked on across from them. Pretty exciting stuff. He took it in stride and said jokingly, "Well, of course it's fine when we ask for it." When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say "I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say "I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Our matter was then called and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Complaining witness accused my client of harassment/stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. "This is Mr. So-and-so, right? Yes, in this photo, he's on a bed? Yes, the bed is yours? Yes, the bed is in your bedroom? Yes, you took this photo of him? Yes, he's smiling in the photo? Yes, and in this photo, he's wearing a brassiere? Yes, no further questions, Your Honor." Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. It wasn't a trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding excess so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, i.e. notes he took during class. He is furious and sues the landlord in small claims for $5,000 state maximum because his notebooks have such huge value apparently. They hire me and I respond, which moves the case out of small claims. It's just the way it works here. After time and r/legal advice, I know this is not the case for every state, but our rule is better than yours. But enough aside. This puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, "No, that won't be happening," and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned, period, end of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. IP lawyer. Deep in a set of terms and conditions on a website, our client's details, name and contact details were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick CTRLF for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me, did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator: sir, answer the question. Silence. Mediator: well, let me ask it, did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator: I'll take that as a no. My brother-in-law is a DA. He was attacked during sentencing by a child molester. The pedo got his hand chains around his neck and was choking him. My brother-in-law fought until the deputy pulled him off, then continued with his recommendations like it didn't happen. We all heard about it on the news later. When we asked him, he said, it was no big deal. He'll take the bruising if it keeps him away from kids longer. My brother-in-law had bruising to his neck/throat and his voice was messed up for about a week. I helped the prosecution rest his case. LOL. I got jammed up during spring break doing dumb spring break shit. So there I was in court to face the music misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each/all. I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and prosecutor were getting tired of their bullshit. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this "let's just get it out of the way. Tell us you're not guilty" look and asked how I pled. Guilty, Your Honor. The judge and the prosecutor both looked at each other and the judge said, "Could you not say again? Or beg your pardon?" Guilty, Your Honor. I did it. Just the way Officer so-and-so's report reads. They exchanged looks again and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time and walked out paying like 110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones.